Before this courtroom even gets started, you need to understand you're about to watch a case where control of the courtroom is the real battle. This isn't just about charges or evidence. This is about authority versus defiance. On one side, you have a judge who has seen this playbook before, calm, direct, and completely unwilling to entertain nonsense. On the other side, you have a defendant who walks in believing he can redefine the rules of the courtroom itself. You're going to hear arguments about estates, trustees, jurisdiction, bonds, concepts that sound official, but when placed under legal scrutiny often collapse instantly. And that's where the tension builds. Because every time the defendant pushes, the judge pushes back harder, not emotionally, but procedurally. Watch how quickly this escalates. Because in court, there's one rule that matters above all else. You can argue anything you want, but you still have to follow the process. And by the end of this, ask yourself, was this a defense strategy or a fast track to something much worse?
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Under the barcode, though, this is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode. All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not for you how it works.
Yeah,
You're on the side here.
Are you representing at the desk, representing yourself?
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections. They are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. What are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oth to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as I come.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not gonna obligate you to stay.
I understand, Judge. I'm definitely
Well-
gonna stay.
That's fine.
so today,
You have a jurisdictional argument you wanna make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple-
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I wanna do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or-
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is
in
not
order-
admiralty,
What
and
is it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
my
record, I need to
jurisdiction
have
is
that on-
both civil.
I can't defend myself unless I have it on the record. Is it,
My
it's
jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a
the-
criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my
Constitution.
ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed, all
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This
says,
is the probable cause hearing.
it says, it's,
All right,
it
stop,
says-
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting
What is your legal objection?
to not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because
have
you
my
didn't
due
give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing, that I did not.
They're the same thing, Mr.
It's
Michaud.
still, on this. it
Mr.
doesn't-
Michaud,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary.
Have you
exam.
ever had a grilled
If it
cheese?
was different,
Have you ever
if-
had a grilled cheese?
if it was different, why would it have two
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud, that probable cause conference is a bit of a misleading name, because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive?
And just like that, the courtroom tells you everything you need to know. This was never really about jurisdiction, trusts, or whether someone is a person or not. It was about one simple reality. You can challenge the system, but you cannot ignore it. What you just watched is what happens when someone walks into court believing they can outsmart the process instead of understanding it. Courts don't operate on internet theories, they don't respond to buzzwords, and they don't bend just because someone refuses to follow the rules. Every time the defendant tried to shift the conversation, the judge brought it back to procedure. Every time he tried to redefine the law, the court reminded him that the law is already defined, and that's exactly where everything began to fall apart. The problem here wasn't that he didn't have rights, it's that he didn't know how to use them properly. There's a huge difference between asserting your rights and undermining your own defense, And in this case, that line was crossed again and again. You probably noticed something else too. The judge never lost control. There was no emotional outburst, no endless back and forth argument. Instead, the court did what it's designed to do: move forward with or without cooperation. Because the courtroom isn't a debate stage, it's a structured process. And if you refuse to follow that process, you don't stop the system. You remove yourself from it. That's the real takeaway. This wasn't a genius legal strategy or some hidden loophole. It was a fast track to making a bad situation worse. So the real question isn't whether he was right or wrong, but whether anything he said actually helped his case or only made the outcome more severe. Because in court, what truly matters isn't how loudly you argue. It's how well you understand the rules you're playing by. And in this case, that made all the difference.